I'd like to call this conditional use hearing to order and turn it over to our hearing officer.
Thank you, Mr. Chairman. This is the continued hearing of Three Creeks LLC, properties at 2069 Bondsville Road. We last met last week on October 16th of this year. The matter was continued on the record for continued testimony this morning. I think that the intent is to call Mr. Joseph Boldaz as a witness, who I do see in the audience. So, are you going to call him, Ms. Dunn?
Yes.
Okay, very good.
Call Joseph Boldaz.
Okay.
Excuse me. All right.
Please, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Good morning, Mr. Boldaz. Thank you for being here. Can you please state your name and spell it for the record?
Joseph Boldaz, last name Boldaz.
And for whom do you work?
I work for Hydroterra Professionals.
And what is Hydroterra Professionals?
They're water resource engineers.
And do you have any contract with East Brandywine Township or the municipal authority?
I serve as the municipal authority's engineer.
And how long have you served as the municipal authority's engineer?
Approximately 20 years.
And has that always been...
Can you keep your voice up, sir?
Voice up.
Voice up. No, the microphone is the green.
Microphone's here. How's that? Is that better?
Yes.
Okay.
During that 20 years, has that always been in the capacity as representative of Hydroterra?
No, initially it was as a representative of Shore de Palma. I would say 3, maybe 4 years.
I'm sorry, I missed that.
Shore de Palma.
How do you spell that?
SCHOORDE-PALMA.
And do you have, are you an employee of Hydroterra or are you an owner?
I'm an owner of Hydroterra Professionals.
Other than the municipal authority of East Brandywine, does Hydroterra Professionals have any other contracts with municipal authorities in Chester County or
Yes.
County? And
Yes.
which are those?
Pardon me?
Which are those?
There's several. London Grove Township Municipal Authority. I do some work in Montgomery County and Berks County.
In which townships?
Marion Township in Berks County. Green Lane Joint Authority in Montgomery County.
And can you just give, for the record, a brief description of your CV, essentially?
Yeah, so I've been an engineer for about 30 years, practicing in water resource engineering, specializing in water and wastewater. I've served a number of municipalities and municipal authorities with that aspect, and review land development plans, review Act 537 plans, create Act 537 plans.
And when you say engineer, is that a PE?
Yes.
Did you, in your capacity as the municipal authority's engineer, did you participate in the sewer allocation updated Act 537 plan dated August 2020 for East Brandywine?
I believe I did, yes.
May I approach?
Certainly.
I'm going to show you what's been previously marked in this 815 in this hearing. Is that a document with which you're familiar?
Just note for the record, it's been marked but not admitted.
Okay, thank you.
I recognize that, sure.
Okay. And what is the purpose of this table 5-2?
I believe Section 5 has to do with alternative analysis of Act 537 planning. So the purpose here is really to determine future potential development in the township and try and quantify approximate gallonage for treatment capacity and disposal.
And are you familiar with the property that we're here today discussing?
I am. I believe it's listed there.
And is it listed as a winter track?
It is.
And would you agree with me, I'm sorry, I'll bring it back if I have to, that the treatment capacity and demand for the winter track is listed at 21 units?
21 units, yes. That's what I see there.
Okay, and the disposal capacity?
It looks like about 50% of the 21 units.
Would you agree with me that the municipal authority, therefore, conceptually allocated 21 units of treatment capacity and demand for 21 units from that property?
No, I would not agree with that.
And why not?
Well, like I said, that is a future potential plan. There's a number of units on there, none of which are allocated capacity. Well, I shouldn't say none of which, but many of which are not allocated capacity.
What if it's not allocated capacity? What's the difference between the treatment capacity as designated in Table 5-2 and allocated capacity?
And that's based on future potential flow. I believe that's included in the alternative analysis. And the authority would not allocate capacity unless a planning module was completed.
And has a planning module been completed?
Not that I have seen, no.
There's been no planning module for?
Not that I know of, no.
Maybe we're not on the same page here. What I'm saying is there a planning module for the municipal authority of East Brandywine Township overall?
There's an Act 537 sewage facility plan for the township overall.
And that is dated 2020?
That's correct. Mm-hmm.
And you were also employed as the municipal authority's engineer in 2012, correct?
I was.
Permission to approach?
Of course.
I'm going to show the witness what has been marked as Exhibit A40. Are you familiar with this document?
I can't say I recognize this. No, it's rather dated to me, but I don't recognize it.
I would agree with you that it's dated. I believe it's actually dated 2012. Are you familiar with where the property sits upon this map?
Could you try to keep your voice up, Mr. Boldas? The last question, did you say you do not recognize it?
I do not recognize this, although I can't say that I've never seen it, but I don't recognize it. I do recognize where the potential property is.
And can you point that out on
Yeah,
the board can see?
believe it's right in this general area.
Right there?
East Reeseville Road. Yes, right there.
And you would agree with me that it
But
is...
for purposes of the record, the witness was pointing to a parcel that has the letters VC on it,
Correct.
correct?
That's correct.
And what does VC stand for, if you know?
Boy, I'd have to look here. Village Commercial, according to this.
Okay. So in 2012, you would agree with me that the property was zoned as village commercial.
I suspect it was.
Did you participate in any way with the rezoning of the property? Did you coordinate in any respect on a committee or with any township officials as the municipal authority's engineer for the rezoning of that property?
Not that I recall.
Would the municipal authority's input be vital to the rezoning of properties in the township for purposes of compliance with the Act 537?
I think, so the Act 537 plan is prepared for the township itself. I guess the municipal authority was asked to prepare the 537 plan. So whether it's vital, I don't know that I could really answer that, but it would be vital if the township to bring that forward, yes.
So I suppose, let me rephrase that then. When the township undertakes an amendment process to its ordinance, specifically for the rezoning of parcels, is there a necessary consultation with the municipal authority in order to ensure compliance with the Act 537 plan?
I would think that the township should engage the municipal authority, make them aware of what the changes might be to that.
And do you recall ever having participated in the rezoning of the previous village commercial district?
I never participated in rezoning, no.
I'm not asking whether or not you participated in the rezoning. I'm asking if you were consulted as the municipal authority's engineer during the process of the rezoning.
I don't know, that was some 12 years ago. I can't recall that, no.
Can't recall. But would it be typical? Would you expect to be consulted?
I would expect to be notified, maybe not consulted, but notified if I was preparing the plan.
And would you provide input based upon any planned or projected rezoning?
Only if requested.
Do you think it would be important for the township to have your input with respect to rezoning from village commercial to TND-1?
I'm going to object to whether he thinks it's important or not. He's answered the question as to whether he did, in fact, participate.
What's the question?
Whether or not he thinks it would be an important role for him to play as the municipal authority's engineer to know if a property is being rezoned from a commercial, village commercial property to a TND-1.
I thought you already asked that, but fine. We'll overrule the objection. He can answer if he can.
I think that the 537 plan is the responsibility of the township, and it would behoove the township to bring that attention to whoever's preparing a 537 plan. I don't know that I can answer the question.
Well, let me put it this way, maybe a hypothetical. As a wastewater engineer, with your experience level, do you see a difference between the sewage flows and requirements for a commercial property or versus a property that is zoned for residential use?
There could definitely be differences in flow rates, yes.
And what would the differences in those flow rates be?
Well, it would depend on what's being proposed there.
And do you have an opinion regarding which would require more treatment capacity and disposal capacity?
No, it would all depend on what kind of commercial is proposed versus what kind of residential is proposed.
Specifically with respect to this property, with which you said you are aware of where the property is and how large the property is, I assume, would there be a difference between a commercial enterprise planned for that property and a residential development?
Well, as stated in that 5-2, I was under the assumption there were 21 EDUs that were potential there. As a matter of fact, I believe Mr. Winters brought that to my attention.
Are there 21 EDUs available for that property?
There are 21 EDUs available for that property, yeah.
Is there disposal capacity available for that property? Outside of that property?
I'm not sure if there's disposal capacity available. I'd need to go back and look at some of the documents.
Are you aware of whether or not there's additional disposal capacity available at the Applecross facility?
I'm not sure if there's additional disposal capacity available out there.
Can you tell us where there is additional disposal capacity available in the township at this date?
At this date, today, no, I cannot tell you.
Is there?
In the future, there is projected to be additional disposal capacity available.
And where does that projection lie?
And so there's the development, Maple View development, and Brandywine Walk development that is building disposal capacity.
And the Brandywine Walk is the NVR development that sits behind the township over towards Bollinger Road?
That's correct.
There's a provision in the municipal authority regulations, is there not, that requires a new development to provide for 150% of its disposal capacity needs. Is that accurate?
That's accurate.
And is that been strictly enforced within every development, to your knowledge?
I think for the Plank Farm, it was determined that 125% disposal capacity could be provided.
And who made that determination and on what basis?
Oh, I couldn't tell you that. I just know that that's how it was approved.
Was the municipal authority consulted in the decision to reduce the 150% disposal capacity requirement in that 25% waiver?
Yes, I do believe they were.
And did you participate in that discussion?
Yes.
And so what was the rationale under which the 25% was waived?
I'm not sure. It had something to do with the roadway and the land available.
So it's not 150% is not necessary for every development.
That's the authority's policy is 150%.
But you agreed at the time that 25% could be waived.
I agreed at that time, yes.
And with respect to Brandywine Walk, was 150% disposal capacity enforced strictly?
I believe it was. I believe it was, yes.
Do you recall if the Pennsylvania Department of Environmental Protection had any sort of concerns about the expansion of disposal capacity beyond what's necessary for the development?
I don't recall them being concerned about that, no.
Okay. While I'm looking for an exhibit, I have one more follow-up question. Do you recall when the municipal authority rerouted the sewage from Little Washington to Applecross?
I am aware of that, yes.
Okay. And at that point in time, do you recall if all potential flows, future flows, required for what was then village commercial were accounted for?
I don't recall that.
Would they have been?
Objection, calls for speculation.
Well, overall, you can answer it if you can, Mr. Baldas.
I would assume they were. I don't know for certain. Again, that's more than a decade ago.
Mr. Baldas, I'm going to show you what was previously marked as Exhibit A38. Which I will represent to you is a Planning Commission meeting minutes from May 7th of 2014, page 5. And the second paragraph on the page, for the record, you could just review that and let me know if that refreshes your recollection.
This has to do with riparian buffers and wetlands, Chapter 102, not something that I typically deal with. I can't say I recall any of that, no.
Okay. You don't have any reason to doubt that this is an accurate accounting of the meeting minutes from that Planning Commission meeting, though, do you?
It certainly could have been in there. I don't know.
Do you recall in the preparation of the Act 537 plan for the East Brandywine Township Municipal Authority commissioning a special study of the Guthriesville area?
I do.
And whom did you commission to perform that study?
Who did I commission to do it? Or who did I do it for? I did the study.
So
for the
Hydroterra?
Township. Yeah,
Hydroterra at
yeah.
that point, or was it the other entity?
Sorry, what year was that?
2001.
That would have been for Short of Palma. Oh, wait a second. 2001.
Was it 2001? Excuse me, 2012.
2012. That would have been Hydroterra Professionals then.
So you performed the study.
I did.
And what did that study consist of?
believe that study consisted of rerouting the sewer flow from Little Washington to Applecross Treatment Plant.
And what was the purpose of the study?
Exactly what I said, to reroute the flow from Little Washington to Applecross.
And what was the conclusion of the study?
That it could feasibly be done, completed.
And did that rerouting increase the ability for treatment or disposal? Well, let's just go with treatment first. Did that increase the ability in terms of gallonage or treatment capacity of the municipal authority and the township?
I'm not sure I understand the question.
Was there an impact upon the township's treatment capacity based upon the rerouting?
So that would have decreased the total amount of capacity available from the treatment plant.
Did you say decrease?
Yes, it would have taken the flow from Little Washington Wastewater Treatment Plant and placed it at Applecross.
Correct, but did it, I'm not talking about Little Washington's treatment capacity. I'm saying for the township as a whole, did it increase the treatment capacity?
It would have decreased the capacity available at Applecross Treatment Plant by rerouting the flow. There was about 60-some thousand gallons, if I recall correctly, that came from Little Washington, was directed to Applecross Treatment Plant. So the treatment plant was designed for 300,000. 60,000 of that would have come from that rerouting. So it would have been a decrease in capacity available.
Why would there be an implementation of a decrease of capacity?
I believe that I'm sorry, ask that question again.
Why would there be an implementation that would accomplish a decrease in capacity?
The authority felt that it was beneficial to reroute the flow from Little Washington to Applecross.
And what was the rationale behind that conclusion?
Treatment plant of 300,000 gallons needs a certain amount of flow to make sure that it operates correctly. Applecross development was not fully built at that point, and I think part of the rationale was that that treatment plant could get off a pump and haul faster.
Which treatment plant?
The newly constructed Applecross treatment plant.
Was operating on pump and haul for a limited period of time, correct?
It was, that's correct.
But once fully constructed, was there an increase or a decrease in treatment capacity as a result of the rerouting?
So there was a decrease in capacity when it was rerouted from Little Washington to Applecross.
Do you recall what the decrease in capacity entailed? What the number was?
I do not.
Do you have an approximation?
For some reason 60,000 sticks in my mind, but I'd have to go back and review that document.
I'm going to show you page 1-4 of the East Brandywine Township Act 537 Sewage Facilities Plan, final draft, August 2020. Are you familiar with that document?
Yes.
Page 4, I'd ask you to look at that, and maybe the following page.
Senate Exhibit
I asked for the board to take judicial notice of it. I mean, it was prepared for East Brandywine Township, so it's a township document. I don't have it as an exhibit. I certainly can.
You have a copy?
I do not. I'll show it to you. I thought this was.
The board will take judicial notice of the finally approved Act 537 plan that we believe is dated August 2020.
Would you agree with me that that indicates an increase based upon the phased expansion?
That would suggest an increase in permitted capacity.
Just for purposes of the record, I don't think you identified exactly what you were showing it.
Oh, page 1.4 under the headline Special Study Rerouting Guthriesville Sanitary Sewer 2012.
And it seemed to say something about pump station B.
Yes, so I will read it into the record. It says in November 2012, PADEP approved rerouting Guthriesville sanitary sewer from existing pump station with treatment at LWWTP, which I believe we can agree is Little Washington Wastewater Treatment Plant.
I agree, yeah.
To a new pumping station with treatment at Applecross Treatment Plant. This approval provided the following: 1, phased expansion of Applecross Pump Station B, parentheses, AKA Bondsville Road Pump Station, close parentheses, from 58,425 GDP to 143,250 gallons GDP. Agreed?
Agreed.
And then phased expansion of Applecross Treatment Plant from 137,680 GDP to 186,430 GDP. Agreed?
Agreed.
So you just testified that there was a decrease in capacity as a result of the rerouting. Can you explain the discrepancy?
Sure,
what that
certainly.
document-
I'd love to.
For a moment, because the court reporter can only take us down one at a time. I just want you to explain for the record the discrepancy between your testimony and the Act 537.
Okay. So when a treatment plant is designed, it is designed with a certain amount of capacity. Applecross was designed with a capacity of 300,000 gallons, design capacity. When it was permitted, the treatment plant was permitted for capacity of the number you just read. I don't recall, 130,000 something. That's because that's how much flow is intended to go there at that point. So DEP will not provide a permit for the entire capacity, the entire design capacity, only that capacity used. As the Guthriesville pump station was rerouted, or the Bondsville Road pump station was rerouted to Applecross, that capacity was increased to address that. So you are correct in it was an increase in permitted capacity, but it was actually a decrease in the available capacity. So I had suggested available capacity with each of my responses. That was available capacity. Anytime we send an additional house to Applecross, the available capacity is decreased.
The available capacity is decreased because there is another unit taking up capacity.
Correct.
No, that makes sense. I suppose what I'm saying is, is it your testimony that the DEP has not officially permitted the Applecross treatment plant for its available capacity, only for the capacity that is currently being used?
That's correct, yes.
Thank you. And how much additional capacity is there at Applecross as we sit here today?
How much available design capacity?
Design capacity, yes.
I wouldn't know that off the top of my head.
Can you approximate EDUs?
There's possibly 60,000 gallons available. I don't know. I would need to look at the Chapter 94 reports for that.
And Mr. Boldaz, when you're speaking of gallons, you're speaking of gallons
Per day, yes.
of treatment capacity.
That's correct.
Now, when it comes to disposal capacity, how was the Act 537 drafted to address current disposal capacity versus future proposed disposal capacity?
So there was an initial disposal capacity that was permitted for Applecross. As future developments came on, they were required to provide additional disposal capacity. That was added into the analysis. For instance, when Brandywine Walk came on along with Mapleview, additional disposal capacity was added and permitted for that facility.
And it was added for, when you say that facility, what?
Applecross treatment plant facility.
Okay, I want to make sure we're staying on disposal capacity as opposed to treatment capacity. Is there disposal capacity available at Applecross? Is that what you're saying?
So when I suggest Applecross treatment plant facility, that includes treatment, collection, treatment, and disposal.
Thank you.
It all falls under that facility.
For the record.
Okay.
So Applecross treatment facility, with respect to the testimony you just gave, doesn't just entail treatment capacity, but also disposal capacity.
Yes.
Does Applecross as a community handle all of its own treatment disposal on site?
Well, I mean, you're mixing up two words, treatment and disposal.
No, I'm trying to actually clarify between the two. Regardless of treatment, does Applecross take care of all of its own disposal on its own grounds?
The Applecross development, which flows to the Applecross treatment plant, is disposed of through the Applecross treatment plant and its disposal facility, the originally constructed disposal facilities.
And is that disposal facility located on Applecross?
It's located on the golf course.
Which is affiliated with Applecross, correct? I mean, as a land development plan.
Yes.
And in the approval of the Applecross land development plan, are you aware of whether or not there is an additional disposal capacity beyond the needs of the Applecross community on the Applecross property?
So disposal includes treatment and, disposal includes drip irrigation and spray irrigation. There was some additional disposal capacity available when that facility was constructed. What is available, I can't tell you unless I go look at the Chapter 94 reports.
Are you aware, without asking you a specific number, are you aware that there is additional disposal capacity at Applecross?
I believe there is not, or it's getting close. Again, I can't tell you that unless I look at the reports.
Now, with respect to just a couple moments ago, you indicated that there is additional disposal capacity at Mapleview and Brandywine Walk, correct?
Once operational, there will be, yes.
And how much?
I don't know.
Can you approximate?
I would say it's 50% of once it's fully constructed, there would be an additional 50% of disposal capacity available.
And that disposal capacity is available for other developments within the township?
That disposal capacity is intended to be a backup to the primary disposal capacity. In case there's a malfunction, in case one of the fields gets fouled.
So it is not allocated to other developments in the community?
That would be up to the township and the municipal authority, I believe. We would have to look at what's available and if they would want to see that happen. I mean, I'm not certain how to answer that question. The original intention was to provide 50% additional for operational issues. In case a disposal field went down, they would still have the ability to get rid of treated effluent.
And in terms of drip irrigation, I'm assuming that drip irrigation is what is the required implementation in both Brandywine Walk and Mapleview. Is that accurate?
That's correct, yes.
And that requires a certain level of infrastructure, does it not?
Yes.
And what does that consist of?
It's a pumping station, it's supply lines, return lines, dripper tubes that are in the ground, certain land area per gallon.
And so when these, specifically, let's talk about Mapleview and Brandywine Walk. When those facilities for drip irrigation are constructed pursuant to an approved land development plan, is it required that the developer construct and implement all of the infrastructure for the 150%?
Not sure how the resolution reads on that. They're required to provide the land area for 150%.
In your experience as a professional engineer, specifically with respect to wastewater disposal, is it effective or practical to reserve the land and not implement the infrastructure?
Yes.
And so that infrastructure can be added on at a later date?
That's correct, yes.
But you're not aware of whether or not the land is being reserved upon Brandywine Walk and Mapleview, or the infrastructure is being implemented?
I am aware that it is being reserved.
Just the land?
Just the land, yes.
Do you know whether or not the township and the municipal authority have ever approved a land development plan and permitted disposal capacity to be directed and allocated to another land development plan?
Not aware of that.
So is there anywhere in the township where disposal capacity is routed to, or disposal is effectuated upon Applecross outside of the Applecross development?
The Guthriesville sewer area obviously goes to Applecross. We talked about that earlier.
Well, I don't want to say obviously, because I'm trying to make sure, because you just said you weren't aware of anywhere that...
That was an existing land development area, right? I can't think of any new land development that has been routed to Applecross to use disposal capacity.
Is there any commercial area in the township that utilizes Applecross disposal outside of Applecross development?
Yes, there is.
And which are those?
That would be the Brandywine Shopping Center. Brandywine, not sure if that's the correct name, the proposed giant.
So in terms of the municipal authorities' calculation of available treatment and disposal capacity, has the Brandywine Shopping Center already been taken into account?
That is, I believe, included in the Act 537 plan, yes. There was an approved planning module for that.
And that would be would that be on the exhibit that we reviewed earlier? The table 5.2?
I couldn't tell you that. I'd have to look at it.
So here, I'm showing you again Exhibit A15, which is Table 5-2 for 537. Is that?
Yes, so under permitted capacity, East Brandywine Center, Walters Commercial, 3 EDUs or 3 units, and 7280 gallons per day of treatment capacity, 7280 gallons per day of disposal capacity. Go ahead.
And has that been permitted yet, to your knowledge?
That has been permitted.
And was it permitted at the time that this was created?
I believe it was.
So these hearings have been going on before this morning. I'm sure you may have been informed, and I know you weren't here to hear some of the testimony, but there was a discussion regarding the fact that regulation that I just discussed with you, requiring the 150%, is also incorporated into the township's saldo. Are you aware of that?
Yes.
Okay. And are you aware of whether or not there is a provision for a fee in lieu of the provision of 150% where that is not practicable?
Not sure if it is if that provision's in the township code or not.
Regardless of
The
whether
authority recognized that fee in lieu, yes.
And are you aware of what the fee collected, hypothetically, is utilized for?
That would be to provide off-site disposal capacity.
And would that be exclusively Applecross, or is there?
I don't think that matters. I don't think it's specified in that fee in lieu.
So it could be used at another site that was able to provide 150%.
I would assume it could, yes.
And would that be for the construction of or extension of the infrastructure as we discussed earlier? Or would that be to reimburse or monetize that allocation to the landowner upon which it's being rerouted?
I'm sorry, try that again.
That was very awkward. I apologize. Would that fee, when you speak about the fee being used to implement off-site disposal, are you speaking of the expansion of infrastructure to permit that? Or is it for some other purpose, such as monetizing that allocation from one property to the property upon which the disposal is occurring?
I believe that the fee in lieu is intended to cover the cost to provide disposal capacity to the development that cannot provide it on site.
But how is it? I understand the concept. I'm wondering specifically, how is it used? Do you have any sort of example in your mind of when this has ever happened?
I have not looked at that in some time. We could look at it and decipher it, but I can't sit here and tell you what it says.
Well,
I don't even want to assume that it says certain things.
I'm not talking about what it says. Are you aware of the township ever having accepted a fee in lieu of the provision of 150% disposal capacity?
I believe there's a fee in lieu for the Brandywine shopping center at this point.
And that fee is to be utilized how, is what I'm asking.
That fee is intended to pay for the cost of providing off-site drip disposal for that land development.
And the cost, when you say cost, are you talking about an easement between the two property owners, that cost, and the township is acting as a broker, or are you talking about the township undertakes the expansion of infrastructure to implement it?
I don't know.
You don't know. That's never come up before in your 20
Ma'am,
years?
you're asking me to dissect a resolution that I haven't seen in years. I can't sit here and tell you just off the top of my head what it's intended to do.
I mean, I'm actually not asking about the resolution or the resolution language. I'm asking about its application practically.
So practically, the sewage would go to one of the disposing pump stations. It would go to the Applecross treatment plant, and from there it would be dispersed to some disposal field. So whatever it costs to get rid of that gallonage on one of the existing off-site or future constructed disposal fields would be what that's intended to cover.
Even if the disposal fields to which it's being routed have already been constructed and have additional capacity?
I would assume so, yes, because there would be a fee
So what would the fee be covering is my question.
If, for instance, the Weaver and Mapleview is required to provide land area for 150%. So that fee in lieu would be to help pay for the cost to build that additional 50% or that portion of the disposal area.
Okay. And earlier, I believe you testified that the 150% was not constructed at the time there would be land reserve, correct?
Yes.
Who undertakes the expansion of the disposal infrastructure when a fee in lieu is paid and used to direct disposal to one of those sites with reserved land?
That would be the authority.
The authority.
Yes.
So the authority takes the fee in lieu.
Authority would take the fee in lieu and apply that to the capital cost for expansion of that facility,
Thank you.
whatever facility.
Have you ever spoken with the applicant's engineer regarding the potential of a fee in lieu for this particular sketch plan?
Three Creeks?
Yes.
No.
Never.
Not that I know of, no.
And in general, when a sketch plan or a preliminary development plan is submitted to the township, do you, on behalf of the municipal authority, review the plan?
We would, okay, I don't believe that this has ever been submitted to the municipal authority as far as a preliminary plan, maybe a sketch.
It's a sketch.
We may have briefly reviewed that. Again, this is years ago, so I don't recall ever talking to the consultant about land available.
And which consultant would you, are you speaking of the applicant's engineer?
I'm talking about Three Creeks consultant.
Okay. Would you have spoken to anyone on behalf of the Township Board of Supervisors regarding the sketch plan? And the municipal authority's position regarding the feasibility of treatment and disposal for that project?
I could have.
You don't recall?
I don't recall, no.
As you sit here today, do you believe that there is any impediment regarding available treatment and disposal for the project that's proposed in this sketch plan?
On-site or off-site? Or both?
Let's take both.
I think that there could be capacity available for that land development.
Both treatment and disposal?
Yes.
Purpose of the record, we're talking about 21 residential units.
Yes.
Okay.
And is there anything about the site itself which would make you think that on-site would not be available or not be feasible? Let me say that.
Well, I haven't been out there and have not done a soils test, but judging by the low-lying area, I would suspect that you could not provide drip disposal on site.
Is there ever anywhere in the township, is there disposal that discharges directly into a stream?
Yes.
And is that the Brandywine River or someplace else?
It's one of the tributaries to the Brandywine.
And so is that infeasible for purposes of this property?
I'm not sure what you're asking me there.
Well, there's been a lot of discussion regarding both the soils of this property as well as the creeks that run through it.
Okay.
And my question is it a prohibition for disposal to be placed into one of
So
the creeks?
if you're asking me, I'm not sure what you're asking me, but if you're asking me, could Three Creeks build a treatment plant on site for stream discharge? I'm sure they could. Could they get it permitted? Most likely not.
What would be the impediment to permitting?
Okay, so they would look at the stream quality and certainly the stream quality would dictate how clean the water would need to be discharged.
And when you say stream quality, are you speaking of the robust flow of the stream?
It's got to do with the flow, but it also has to do with total nitrogen and other constituents that are already existing in that water.
Okay. Just one moment, I'm sorry. Mr. Foley, do you have a copy of your exhibit T5? I don't know. Thank you, sir. I will. Mr. Bolda, last question for you. I'm showing you what has been marked as Township Exhibit 5, which is a letter from the Pennsylvania Department of Environmental Protection, Township Manager dated January 25th, 2024. Have you ever seen that correspondence?
I have.
And did you, as the municipal authorities engineer, assist the township in any way with the submission that is addressed in this letter?
Yes.
And what was the purpose of that?
That was the Township's Act 537 plan, and it was to look at alternatives to treat additional flow to Applecross and existing on-lot systems in the township.
And this letter indicates that the DEP acknowledges that no expansion of the sanitary sewer system is proposed, correct?
That's correct.
And is that accurate with your consultation with the township's municipal authority?
That's what was submitted. That's consistent with the Act 537 plan that was submitted to the township.
So when it says no expansion of the sanitary sewer system is proposed, is that speaking of treatment or disposal or both?
Both.
So if there's land that's being reserved for future disposal, is that an accurate reflection of the township and the municipal authority's intentions with respect to this communication to DEP?
I'm sorry, can you try that again?
Sure. This indicates that the township and the municipal authority communicated to DEP that no expansion of the sanitary sewer system is proposed. Earlier, you testified that properties that have implemented the 150% disposal requirement hold the 50% in reserve without infrastructure for further expansion. So I'm just trying to understand.
So that 150% would have been included in the document that was submitted to DEP.
So those are all, so the future expansion reserve areas that are currently in the township as part of approved land development plans have already been permitted.
I'm sorry, say that again.
Land developments within the township that provide the 150% disposal areas holding the 50% in reserve have already been permitted.
Correct.
That's accurate?
That's accurate.
Okay. And so no additional permitting from DEP would be required for expansion of those drip irrigation areas?
No permit would be required for expansion that's mentioned in the permit. In other words, if there's 150% permitted, then 150% could be constructed without any additional permitting.
But what if the land is held in reserve, as you testified earlier, is the case?
That's already permitted by the state.
It's already permitted.
Yes.
No additional permitting would be necessary. Okay. Thank you.
Now, planning would be required.
And as part of that planning, would there be any permitting process for DEP?
The permit may be revised to reflect that disposal capacity.
So you would take an already approved permit and
It would modify it,
information?
yes.
Okay.
So as you read that document that suggested Applecross capacity was increased by the rerouting, so DEP increases the permit as additional land development comes on.
Okay. Thank you.
Through planning.
Thank you. Generally speaking, has this property been contemplated in any permit that the township has received from DEP?
No permit.
Okay. How about any planning module?
No planning module.
Okay.
537 plan that you see assumes that as future potential.
Yeah.
For that to move forward, they would need to submit a planning module.
Yes.
Okay.
Okay. Thank you very much. I have no further questions.
Foley, you have
Yes,
any
thank you.
questions?
Yes, thank you very much. My name is Edward Foley. I think we actually did speak on one occasion many months ago. I've been asked to represent the Township's Administration and Planning Commission with regard to this application by Three Creeks. So I just have a couple questions. The table 5-2 that lists the assumed future capacity for the Winters tract, is that a commitment by the authority to preserve that number of EDUs as available for this property?
No, it's not.
And is it the equivalent of a will serve letter?
No.
I was interested in your testimony about the purpose of the 150% requirement. May I approach?
Certainly.
showing you what I pre-marked as T14, which I'll represent is a copy of section 350-47 of the Township subdivision and land development ordinance. I'm drawing your attention to the second page. The very last highlighted item or phrase says that the land area shall be sized at 1 1/2 times the land determined necessary in accordance with the applicable laws and regulations. Could you read the rest of that sentence?
The land area shall be sized at 1 1/2 times the land area determined necessary in accordance with the applicable laws and regulations to dispose of the total effluent generated by the site in order to provide a safety factor which will ensure an adequate disposal area in perpetuity.
And is that consistent with your earlier testimony about the purpose of the extra 50%?
It is.
My question then is, Ms. Dunn was asking you about the use of the extra 50% on projects to accommodate sewage flows from a new project. Other than Applecross, which is a golf course, has that been done to your knowledge in the township?
Not that I know of.
With regard to the two projects that she mentioned, Mapleview and Brandywine Walk, you mentioned that they will have additional future disposal capacity equal to the 50% set aside to protect those properties and their future disposal capacity. Has the township and the authority ever approved the use of that extra 50% to your knowledge?
Not to my knowledge, no.
Thank you. You were not here for the testimony and the hearings on this matter, but I'll represent to you that the applicant's own engineer acknowledged that this site is in fact not suitable for on-site disposal. Has the applicant approached the authority with regard to making arrangements for off-site disposal?
Not to my knowledge.
And if the capacity at Applecross got allocated to other projects, upcoming other projects, I think your testimony was that there's no guarantee of the Winters tract getting the 21 EDUs.
That's correct.
Is there, to your knowledge, another tract other than the Applecross site where that future development could go, could do their?
Yeah, that future development could go onto the Weaver Tract, Brandywine Walk, if it is determined that their annual usage is less than what is permitted.
And I'm sorry, did you say Brandywine Walk?
Brandywine Walk, Mapleview, it's a joint disposal area.
Yes. But that 50% I thought was allocated to, quote, to ensure an adequate disposal area for them in perpetuity.
You're correct on that, Ed. So when a land development, when disposal capacity is developed or treatment capacity is developed, it's based on planned flow rates. And the Pennsylvania DEP allows a permittee to use actual flow rates over a 5-year period to demonstrate additional capacity.
If the township and the authority determined that they wanted to allow disposal, off-site disposal for a Three Creeks or other project onto those sites, would that require a different permit or a permit modification, given that we're now adding additional off-site flows onto those properties?
I believe it would be a permit amendment based on a planning module submission or approval.
Thank you. That's all I have. Thank you. Oh, I'm sorry. It's not all I have.
I would have one follow-up, Mr. Valdez. You indicated that you were not aware of...
May I have a moment?
Oh,
I'm sorry.
certainly.
Thank you.
Yeah, I think there may be additional questions from Mr. Foley.
I'm being told that, is it correct that the Applecross discharge facilities were designed to include stream discharge?
That's correct.
However, is the stream discharge component, has it been permitted?
Sorry, say that again?
Yes, has the stream discharge component of that plan been permitted?
Oh, it is permitted, yes.
It is permitted. And is it permitted now for normal operation?
Not for normal operation. That's reserved in case there's a problem with spray irrigation or drip disposal.
Including,
I'm not sure how it's worded in the permit, but
right, that could include such things as unusual weather events that preclude spray over a
correct.
period of
Yes,
time.
correct.
Okay, thank you. Thank you. That's all I have.
Okay.
Thank you, Mr. Foley. Ms. Dunn, do you have any further questions?
Yes, thank you. I only have one further question. Mr. Valdez, you testified that you were not aware whether Three Creeks has approached the township or the authority regarding off-site disposal.
That's correct.
Have you been advised or included in any discussions regarding a proposed collaboration between a proposed development at 500 East Reesville Road in conjunction with the Three Creeks property?
No.
No one has consulted you regarding a shared plan between the development of those two properties?
What's the property name for 500?
It's 500 East Reesville Road, and it is owned by 500 ERBY Trust.
I'm not aware of that. This was recent. One of my engineers does sit on the authority board. So he may have been, but I have not been. Not that I recall.
And would you have any opposition, in theory, to a proposal to the township whereby 500 East Reesville Road is developed and the Three Creeks property reserved for township use for either disposal capacity or whatever?
There's disposal capacity, treatment capacity available. I would be in favor of providing public sewer for those.
Thank you. Thank you very much. I appreciate your time this morning.
Thank you.
Thank you. No further questions.
Thank you.
Board members have any questions?
Sorry.
None? I do want to try to clarify something. I believe in response, well, let me just ask it this way. Did the developer of the Maple View residential development. Design, get the permits for, and construct the facilities necessary to dispose of treated effluent.
I'm sorry, Tom. Can you say that again?
Say it another way. Did the developer of Mapleview, which is, you know, is a residential development, correct?
That's correct.
Did that developer do the design, get the permits for, and construct the drip disposal facilities and whatever other facilities were necessary to dispose of the treated effluent from that development on its property, Mapleview's property?
Yes, yes. And
That was not paid for by the authority.
that was not paid for by the authority.
Those facilities, will those facilities be dedicated or ownership transferred to the authority at no expense to the authority?
That is the intention, yes.
And if I ask you the same questions about Brandywine Walk, in other words, did the Brandywine Walk developer design, get the permits for, and will construct those facilities
That's correct, yes.
and dedicate them to the authority?
That is the intention, yes.
Thank you, because thank you.
May I ask one follow-up?
Sure.
Question? So I believe what Mr. Esty just asked and you confirmed, then for those two developments, Mapleview and Brandywine Walk, the land is not being held in reserve. That those developers have undertaken to construct the infrastructure necessary for 150% and to dedicate it to the municipal authority?
The intention is to dedicate 150% of that area and all the facilities to the municipal authority.
And so, as a follow-up to our earlier dialogue, what would the fee in lieu be used for as a land development applicant who cannot provide for that 150% requirement?
Object, because I think the form of the question is assuming that he answered your question the way you intended it. He has not testified that the extra 50% of actual disposal facilities have been constructed.
I hate to ask the court reporter to read it back, but I'm positive that that's what I heard Mr. Esty ask him specifically.
Yeah, that's what you asked him, but that's not what he answered. That's why I'm objecting.
I thought Mr. Esty asked you whether or not the developers of Mapleview and Brandywine Walk had developed, designed, permitted, and constructed the total effluent disposal facilities for their projects, including the 150%.
They provided the area for 150%.
But not the infrastructure.
Or 100%.
Okay. And was that your understanding as well? I'm sorry.
Yes.
That was...
Developers, correct.
No, I know. No, nothing further. Thank you.
Thank you very much.
Thank you. No, nothing further. Thank you.
Okay, is there any other witnesses or evidence to present to the board?
Is it possible for me to request a 5-minute recess just to check with our engineer? And
We
then-
have a
I
hard-
know. 11
we have a
o'clock
hard
hard
stop at
I
11
understand.
o'clock.
Okay,
Thank you.
thank you. Girl, I'll get you out of
We ready to go back on the record?
Yes.
Thank you.
We have nothing further. We've concluded, I don't believe closing arguments are necessary to the township, but I would like to make, or the opportunity for a written submission.
Yeah, maybe we can go off the record and talk about this. Okay, we can go back on the record then?
Hold on just 1 second.
This isn't a court.
There's not a minimum page. The applicant closes their record, Mr. Esty, and requests I believe we already addressed this, but to the extent that we didn't, I move for the admission of applicant's exhibits A1 through A47 with the exclusion of, right? Okay. Yeah, A1 through A47 and the previously acknowledged judicial recognition of the Act 537 plan, and obviously whatever ordinance provisions were discussed.
Yeah, the board will take judicial notice of its own or the township.
Thank you. And the Act.
And the Act 537,
Thank you.
most current approved version.
Thank you.
Mr. Foley, any objections?
Yes, I do. Would you like them now, or would you like them in writing?
Why don't you give your objections to me, or give them to Ms. Dunn as soon as possible, and then submit them to me, and we'll decide those with the decision.
Thank you.
Is that satisfactory?
Thank
Happy
you.
to do that. Then I would only ask for the admission of the one additional exhibit, which is one of the ordinances that you already agreed to take judicial. The T14 today.
Any objection, Ms. Dunn?
None whatsoever. And then furthermore, on the record, Mr. Esty.
No, I don't think, did we go on the record? Oh, I see your hands moving.
On the record, I would like to acknowledge the stipulation to an extension of the board's time to make a decision upon this application to, I believe, December 4th at the public morning hearing. Is that accurate?
It is. So would you also send me an email or a letter confirming that extension?
100%.
Thank you. So just to reiterate, the Board of Supervisors will make a decision on this application on December 4th, 2025 public meeting. The applicant has graciously given the board an extension of time to make that decision on that date. The board will accept written findings of fact, conclusions of law, and legal or factual argument by November 12th, 2025, and you can submit those to me directly. Mr. Foley will supply to Ms. Dunn as soon as possible his written objections to the admission of any documents that he objects to. Ms. Dunn can file a response to that with her submission, and the board will decide those objections along with the written decision. Is everyone in agreement with my statements?
Yes.
Very good, thank you. So then we'll close the evidentiary record of this proceeding this morning and follow the procedure accordingly for decision. Thank you.
Thank you all.
Thank you all.
Appreciate your time.